think what you're saying overall is don't be a coward. Cowardice brings this upon our heads.
Yeah, to some extent. I mean, a lot of it's it's ignorance too, you know, and so that's why we're here is
Well,
to
everybody
learn.
has just to, oh, I don't want to do that.
Yeah.
I wanna,
And
Well,
apathy.
they're scared, empathy, yeah.
They're scared.
Well, if you do nothing, then you're at least partially responsible when they violate the next guy's rights. And that's one of the reasons that I do what I do. Because when they violate my rights, I have to say something. Because if I don't, then I am at least partially responsible when they violate the next guy's rights. It's my responsibility, because you cannot sue the government for perjuring their oath of office when they haven't harmed you. If they've harmed me, then yes, I can go after them. But they gotta harm me first. All it takes for evil to succeed is for good men to do nothing. The important thing is do something. It's not necessary to use these forms like they are. Make your own up. I mean, use your own. A lot of them I've done over a long period of time, and so there's a lot of stuff in there. I mean, it's all in there, very calculated and very deliberate. And so you might want to use a lot of that stuff in there, but I mean, it's your document. You do it how you want to do it. I mean, there's things that I've changed for Canada, and that's in these documents right here. And in fact, I think that I need to put in some more things. I need to stress on claim of right issues, because that's in the criminal code, and you have the right to, and even in their criminal code, you have the right to use whatever force necessary to protect your claim of right. You see what I'm saying? And so I think I need to stress that on more, because that really gets their attention. The following process builds a track record in the case showing your assertion which is admissible as evidence in court. And they already know you're sovereign. This procedure builds a case against your public servants for multiple felonies. A felony is an indictable offense, okay? A felony is, at common law, is in the States they call them felonies. But if you think about it, an indictable offense is an indictment, okay, is something that's handed down by a grand jury. And they don't have grand juries in Canada, but they do have indictable offenses in the criminal code. And that's equivalent to a felony. Anyways, they will never do anything that comes close to admitted they've committed any of these multiple felonies. And if this procedure is done properly, the system will take care of your problem for you. You'll rarely get a response. You have to learn to read between the lines if they do send a response. And if they do not send a response, then they've acquiesced.
How long they got to send a response?
30 days?
Yeah, I
2
wouldn't
weeks?
even give them that much. I give them as much time as they need. I send them the document, and then I don't send them anything else unless they perjure their oath of office. Okay? So that's unlimited amount of time.
I've done that with CRA 3 months ago now, and I haven't got nothing from them.
Yeah, they're slower than 7 years itch. Yes?
I find I do what they do to me. If they give me 10 days, I give them 10. If they give me 3, I give them 3.
It's up to you however much you want to give them, but if you're in the process, if they're violating your rights already, then I would do what he's talking about. But I go at it before they even have me on the radar, okay? Before they even see me, okay? Before they're even talking to me, I'm sending them this stuff because then if they ever communicate with me for any reason, then I got them for perjury of oath, because they don't even have any authority to communicate with me. I don't care what they want to say to me, okay? Unless they want to send me money. I mean, then I'll forgive them. But otherwise, if it's wanting to communicate with me for any other reason, then it's perjury of oath. And I developed this system on the foreclosure in Arizona, disturbing the peace, and I sent out hundreds of these registered letters. I sent out registered letters to every member of the U.S. Senate. That's over 100 right there, or that is 100. And those were dear perjurer letters, eh? Sure they like that. Anyways, those are about 18 pages long. Dear perjurer, this is how you violated my rights. Anyways, notice and demand. Okay, so what I do, and these are actual documents right here. If any of you feel like you can witness them for me, I'd appreciate it. All it is you're witnessing my signature. Let me read the witness statement. Okay? It says, "We, the undersigned witnesses, who are sovereign living souls, each and every one of us, and inhabitants of the land of Alberta, do hereby certify that we witness the signature of Glenn Winningham, House of Fern, who is also a sovereign living soul and an inhabitant of the land of Texas. And so, all you're doing is you're saying you saw me sign it. That's all you're saying, okay? If you feel like you can do it, that's great. If you don't worry about it. It's all right. You know, anybody that'll do it, that's great. So, so what I do first of all is I have a notice and demand, and it's about 11 pages, and it goes through.
Isn't the criminal complaint first?
No, criminal complaint comes after. Criminal complaint's when they're violating my rights.
Oh, yeah, and then
Okay.
you do the notice and demand.
No, I do the notice and demand first before they violate my rights, or at least I try to. If they're already violating my rights, if I haven't sent them a notice and demand, I have to see. The purpose of the notice and demand is to build a case that you can say that they don't have any right to presume, okay? Because right now they've got all these presumptions that they can take. You see what I'm saying? So the purpose of the notice and demand is to take away their presumptions. And so I rarely file a criminal complaint on them unless I've already sent them a notice and demand. Okay, I gotta send them a notice and demand first. In your case, we went and did the criminal complaint anyways because you'd already done some stuff. Okay, you'd already made certain arguments,
Yep.
and that was on the record. Okay,
Yes.
and so but I don't go into their court. Okay, that's why they issued that warrant in Arizona, because I didn't show up for their kangaroo court, because it's a show
appearance.
trial.
That's
Huh?
appearance.
So I don't go in there and I tell them that. I'm not going in your court unless I drag them in there. If I drag them in there, then and in my criminal complaint that I'm preparing in this lawsuit, actually, I'll tell them, I told them that if I go into your court, it'll be with 26 of my peers, to bring in a grand jury and witness the indictable offenses that go on. Sure they'll like that. I'm kind of an in-your-face sort of guy. Anyways, so the purpose, notice and demand, notice is common law, okay? I mean, notice is everywhere. You think about it. I mean, they put up speed limit signs all over. That's notice. That's what that is. That's notice. For all the subjects that have to follow those speed limits, then you got your notice. Notice is common law. Yes.
What is the meaning of every one of those signs or whatever is in a black box? It means that it doesn't really exist.
That takes it off the page. Yes, that's right. It's gone. It's nothing there.
Okay, where does it state that? Where is
That's
that?
international law.
Okay.
Matter of fact, if you look on those land patents, the Canadian land patent is in a box. It's the Crown patent and also the Texas one. Is the U.S. patent in a box? No, it's not. Yeah, see here? This is a Texas land patent. It's in a box. Okay? There's nothing on that page under the law. There's nothing there. Same with this one. This is a Canadian land patent. That tells me that they know that they don't have any authority. You know why they don't have any authority? Because they stole it from the Indians, from the original people.
So it's all colored.
It's all color of law, right?
Exactly.
And we'll go into that when we start talking about land titles. It's all color of law. Matter of fact, in the court cases, it even talks about it. Okay, so notice is common law, okay? They provide notice, we provide notice, okay? Demand, again, sovereign's demand. I demand. It's not negotiable, and it's now. This is administrative procedure, okay? It's also common law. This gives notice to the authorities about your assertion and gives them an opportunity to rebut it. Defeats their presumptions. Okay, so we'll go through the actual paragraphs, okay? And these are pretty standard paragraphs. I go through and I just make a few changes, and like what I do is I'll put in the new address of whoever's getting it, and then I'll copy that, and then I'll paste it into the first, the name. Each paragraph says, it basically, like for example, it says, paragraph 1, William Blair, Chief, Toronto City Police, I accept your oath of office. Please find an oath of office acceptance document attached here to and incorporated herein by reference in its entirety. Okay, so here's the oath of office document. And so I give them an oath of office. And essentially what that says is you don't have any immunity against me, okay? And your corporate law is color of law, and you have no immunity against me. And so then every paragraph starts off, William Blair, Chief, Toronto City Police, equality under the law is paramount.